Good evening, friends. Today we will be taking a session in different perspective that majority Mr. Yuvraj and Narvankar will be taking and giving us insights in primarily English. And then we have requested him also to take his sessions, his thoughts in Hindi. And though I won't be able to understand Marathi, but he will also somewhat give us a glimpse, and I will also try to understand the nuances in the Marathi language because I would have heard through English and Hindi. And I'm not taking much time on the introduction because since it's divided into three parts. Certification process for digital evidence under Section 63 of the Bharatiya Sakshya Adhiniyam 2023 has gained a lot of importance. And as a practitioner and otherwise also, one would like to understand this nuance. And as I said, I will not take much time. And we are glad that Mr. Yuvraj has accepted our invite. Though he has told me that after the creation of two benches between Kolhapur and Mumbai, his hands are tied, legs are tight, but his style of speaking continues to remain better and better. Over to you, Raj, and thank you for accepting it.
Thank you. Thank you so much, Vikashji. I'm so happy to be back at Beyond Law. And as expected and as it should happen, the subscriber base has gone up substantially high. So congratulations to you, Vikashji, on that. So today, as the topic goes, is the certification process for the digital evidence. Now, one thing I must put in perspective before I begin, and as Vikashji said, yes, at the end of the session, we will have a part of that in Hindi, part of that in Marathi. But those were just 20% of the session. The majority of the session would be in English, but I can assure you that I'll try to sum up everything in Hindi and Marathi at the end of the session. So friends, I must tell you one thing. Why this topic and what was the need? I have spoken on this earlier, but today is going to be little different, not much of a difference, but there is going to be some and today the topic is it's not going to be a lengthy session. It's going to be a very short and very specific section. I hope you're aware of a judgment of the Pune Bar Association, which is delivered by the Honorable the Chief Justice. Now, this is the judgment that is really, that is what prompted me. There are two prompts, for this session today. The one is that judgment, because that judgment told me that under Section 63, which is our old Section 65 capital B of electronic evidence, the certification of a digital evidence is a mandatory process. It's no longer optional. The Pune Bar Association, and with great credit to them because they brought out something which is of immense significance, they said that, look here, you are compelling us to go for a certificate of expert. You are compelling us to go for dual certification. We will go there under the new act. If we have to have electronic evidence produced in the court of law, you have to have two certificates, one by the client or the proponent and one by the expert. Now, the argument of Pune Bar Association was that it is impossible to get hold of an expert for every single thing and to ask and produce that in the court of law. And therefore, this is impossible. And therefore, what was impugned was Section 63, subsection 4. And inter alia, there were other grounds as well. And the Honorable the Chief Justice and the bench said that in the age of AI and deep fakes, this is not too much to expect a litigant to come to the court with certain degree of authenticity. And it is precisely for this reason there is a hash value and there are new certifications which are prescribed. Therefore, please don't feel threatened by them. In the words of the Honorable Supreme Court, don't feel suppressed or don't feel threatened by them. Welcome it with the open hands. It's for your own benefit and safety. And therefore was upheld the constitutional validity of Section 63, subsection 4. My friends, the impact of this is going to be multifold. Henceforth, you will have to have a formality of 63.4 done in every single case that goes to the court of law. You cannot possibly argue that, my lords, it is impossible for me to catch a hold of an expert. This is a case of, hardly few thousand rupees, or, the stakes are not that high that I get an expert to the court. Sorry, the expert is mandatory. And what if you don't get it? Friends, I'll go to the judgment part today in the course of the session. There was some leeway kept open in Arjun Pandit Rao Khotkar by Justice Nariman, saying that in the event of an impossibility, you can just, seek an exemption from the certificate. because the law doesn't compel the impossible. That was a Latin maxim employed by Lordship Justice Nariman. But as we call it, I won't call it a legislative overruling strictly, but now as the section would indicate, coupled with the reading of Pune Bar Association judgment, I think that window is minimized. It's narrowed down substantially. And therefore, it is going to be a very, very difficult time for us in the event if we have to produce and successfully prove an electronic record. And therefore, this is the reason for the session, that we must be very keen to learn and adapt to the new age of electronic certification, the digital certification as prescribed by Bharatiya Sakshya Adhiniyam. So let us begin with the topic. Assume that you are sitting on some lazy afternoon in your office and a client walks in. And she's a lady in some family court proceedings, and she says that, sir, I have this case, and this is the evidence I have against my spouse. And these are the 400 snapshots or the WhatsApp messages or the emails. I'm just assuming a number, some substantial number, the images that I want to produce in the court of law. Now, the first question you will have to encounter is it necessary for me to have a certificate for each of these electronic evidence? One, is it necessary for me to have a hash value of each of these electronic evidence? Second, and thirdly, suppose if I get an expert to do this job, what's going to be the sanctity of that electronic record? Is it still vulnerable to challenge? What challenges I am going to face despite the certification? And this is what we are going to discuss today. So this is what the scope of lecture is going to be. So please imagine a situation where you are dealing with an electronic record, may it be a civil suit, where you have an email from the defendant, may it be a family court proceedings, where you have a WhatsApp chat by your opposing spouse, or may it be a criminal proceedings, we are dealing with the CDR or some kind of forensic piece of digital evidence. So let's begin with the basics. And we will have the basics for first 10 minutes. So it will set a stage for us to discuss and go into the details and the technical nuances. Friends, the BSA brought sea change in the electronic world or digital evidence. The first biggest change was a definition change in section 2 small d. That section defined what is a document. A document is anything inscribed on any substance by any means. It was an old definition in the Indian Evidence Act of 1872. Now, the word document expressly includes emails, servers, call messages, CDR, websites, locational evidences, and whatnot under the electronic record. Now, word document has now been amended so extensively that every single piece of electronic record is a document. Please try to digest it. Let it sink with you. The reason is, today, earlier we used to have a document one and the electronic record on the other hand, because we had 62 primary evidence and secondary evidence, 63, and we had 65B electronic record. These two were the different classes. These classes are abolished. Now it's just the one documentary evidence. It is going to have some impact on the trial. We will discuss. So please mind this. 2D is the first change. Then comes the change in section 2 small e. The word evidence has also been changed. Now, oral evidence will specifically include the statements made electronically. For example, if people are cross-examining me and I'm on a VC from US, that amounts to oral evidence. It's just not the physically when I'm there, it's an oral evidence. Everything I say, even through VC or through platforms like Zoom, is going to be an oral evidence. That's the definitional change in the definition of 2E. And documentary, again, part of 2E as well, as I said. Electronic record specifically is now made a part of documentary record. What I really want you to have a look at in terms of the digital evidence is section 2, subsection 2. It says that something which is not defined in this section or in this act, it is specifically cross-referring to Information Technology Act of 2000. Please mind this. So if there is a definition of a data, for example, now definition of data is not there. But if you look at the Information Technology Act, it will give you a definition of data. So wherever it is lacking in the terms of defining something, you have a cross-reference to the Information Technology Act, which is what you should all keep in mind. So if there is something about electronic record that you are not getting your hands on, please go back to the Information Technology Act. That's what the Section 2.2 is about. Now let's go a little ahead and understand what has changed. And we will come back to Section 39, which was old Section 45 in a while. Let me fast forward you to Chapter 5 of the Indian Evidence Act, because this is something very important. Earlier, there was a part of 65B, as we all know. Now that 65B and that thing is gone. Now this is very much a part of the topic of documentary evidence. And therefore, let's come to Part 5. Now, please look at the definition clause of Section 57, which defines what is a primary evidence. Primary evidence is very simple. Document produced for the inspection of the court is a primary evidence. We all know the definition. If there is a cell deed, अगर कोई सेल डीड है, अगर कोई ईमेल है, मैंने उसको कोर्ट के सामने प्रोड्यूस किया, then basically it's a primary evidence, the document itself. There's no definitional change. But look at the illustrations below, and you will find now there are 7 illustrations below Section 57, and this is very important. Please understand this. Section 57 now comes with these added illustrations, and you will look at those illustrations, and you will find that explanation number 4 says that if any electronic record, as I said, friends, just give me like 10 minutes to brush up the basics and we go to the certification part, which is going to occupy us for next 40 minutes. Let me just quickly run through these sections. 57, there are 4 added illustrations. First is illustration number 4 that says any electronic record, if created and stored simultaneously, each of the record which is created is a primary evidence. And I always give this example कि अगर मैंने iPhone के through कोई तस्वीर ली है, and then if there is a backup being stored in iCloud, then not just the image that is on my phone, but also image on iCloud, because it's getting created simultaneously, is also primary record. Otherwise, in the old regime, it could have been cited as a secondary evidence. Now it's a primary evidence. So mind this. This is illustration number 4. Come to illustration number 5. It says if any electronic record is produced from a proper custody, then it's a primary evidence. Now, what do you mean by primary? The proper custody. This definition, friends, you will get in the proviso to Section 81. And this is something you please understand this. Proper custody means a custody by which something is required to be kept in the custody of someone. The law requires it to be in the form. If it is kept in the form as law requires it, and if it is kept with a person, the law requires. So basically, if, for example, let's take an example that there is a CCTV installed in my office. Now, the law technically obviously will require the owner to have a custody of that, right? The juridical possession. So I am the proper custodian. A stranger or a client coming to my office is not a proper custodian, as simple as that. But then it says, no custody is improper if the origin is probable or legitimate. Now, please understand this. For example, if at this crime scene, there is a pen drive lying on the spot, which is not owned by anyone. The police doesn't know who is the owner. It's just lying there, and it might have some incriminating evidence. Now, who is the proper custodian? Now, the IO obviously is going to seize it as a part of the evidence, and he's going to obviously produce it. Now, is he a proper custodian of that? No, technically the pen drive doesn't belong to him. But the origin with him is legitimate. It's probable. And therefore, he becomes a proper custodian. And that is what is the importance of proviso to Section 81. So please understand, if an evidence is coming from the custody of the person who is a proper custodian, it becomes a primary evidence. However, in the hands of someone who is not a proper custodian, the same evidence will partake the nature of the secondary evidence. Okay. For example, my CCTV in the hands of a stranger is a secondary, and my CCTV in my own hands is a primary evidence. So same evidence taking 2 avatars depending on who is the custodian. So this is the beauty of explanation number 5. And I will connect this, how it is going to pose some problems in the course of the trial. Please come to illustration number 6. It's again very easy. If the video recording is simultaneously stored and transmitted, broadcasted, or transferred to any other device, then each of the video recording is a primary evidence. For example, there is an IPL match going at home. I'm not at home. I want to watch it later. It's stored in my, let's say, some set-top box. It's being relayed live, but it's also getting stored in my device. Both of the copies are the primary evidence. The one which is stored and one which is transferred or transmitted. All of that is a primary evidence. And the last illustration, that in any device, if there are multiple storages occurring at the same time, automatically, each of those storage is a primary evidence. For example, what do you mean by automated storage? Now, if I'm working on a Word file, I always give this example, and if the light goes off, and you will see word prompt coming up that did you want to save the file? Before the computer went off, you were working on something. Now do you want to save it? So did you save it? No. But was it automatically saved? Automatically stored? Yes. Now that temporary file is also primary evidence. Okay, so this is what the explanation number 7 tells me. So multiple storages happening automatically, all of them, including the temporary files, is a primary evidence. No difficulty on this. Now, for a minute, let's skip these two sections, section 58 and section 59, not on 60 as well. Not much of an importance in the context of digital evidence. Please come to section 61 before we jump into the topic directly. 61 tells me, and this is something new. This wasn't there earlier. 61 tells me nothing in this adhiniyam shall affect admissibility of any electronic record, just because it is an electronic record, and it shall have same admissibility, legal effect, and validity as any other document. What do you mean by this? This is something important. Suppose this is my electronic record, electronic device, and there is a paper document. Section 61 tells me that we have not just stopped by amending section 2D. We have now removed literally, entirely, the difference between an electronic record and a paper document. And therefore it says that nothing in this adhiniyam shall affect the admissibility of electronic record just because it's an electronic record. So please don't discriminate between the electronic record and the paper record. They both are at par when seen from the lenses of law. And they will have same legal effect, admissibility. So one thing is very clear, that now there is no distinction between the two. But there comes a catch. And here it's the topic, here is where the topic begins. It says, however, this will be subject to compliance with section 63. Now, this 63 is a reincarnation of section 65, capital B. Please understand this. The law is telling me that I will consider paper document to be equivalent of an electronic record only if you comply with 63 in terms and in spirit. Now, therefore, let's directly go to section 63. 62 tells me that electronic record may be proved by resorting to 63. So it's just a gateway, as we call it. So please remember these three keywords. 61 is equality, that these are equal. 62 is a gateway to 63, and 63 is the real section. Now, section 63 is something that I would really want you to decode. And this is where the devil lies, if I may put it that way. 63 tells me that nothing is changed. It is exactly, if not identically, almost same worded as 65 capital B, and there are certain changes which are important, and we are going to only talk of those changes. 63.1 says that notwithstanding anything contained in this act, any information contained on electronic record is deemed to be a document. So this deeming fiction is very important. This is considered to be a document. Again, law is telling me third time. 2D it told me once, 61 it told me second time, and third now it's saying it will deem to be a document when you comply with 63.4. So 63.4 is a certification section, which is where we are going to discuss how to go about the certification. So the law shall deem an electronic record to be a document if you comply with 63.4. Now, please understand this, and I would now want you to look at the section 63 and tell you something. I would just, Vikas ji, with your permission, will share the screen.
Just check it out.
Yes. I want the readers to be with me when I read section. No, the host isn't allowing sharing for this meeting.
You just continue, I'm just allowing it.
Okay.
You go ahead.
Should I?
No, I'm saying you go ahead with the session. I'm just allowing
Oh,
this.
no worries. Just let me know. Sure. So please understand, I will be just highlighting on few words in section 63 that will help you in the course of the trial to explain to a judge as to why you are arguing the way you are arguing. Okay. First thing, please understand, notwithstanding means that nothing in the section, everything in this section will prevail. Nothing else will matter for you when it comes to electronic record. Then anything printed on a paper, please understand, if an email is printed on a paper, it doesn't become a document, it will still require a certification. Other day we had a case where a document, an old will was scanned with my client, and that scanned will was sought to be printed on a paper and produced in the court of law. An argument was raised by the respondent saying, no, this is now electronic record printed on a paper, and therefore it must have a certification. So please understand, I have said that in my book, not required. The origin of a document you must have a look at. The creation of that will was not electronically generated. It was a will which was in a paper format. It was a document which was scanned as a means of storage, and then it was printed for the sake of producing in the court of law. So please understand, only if the origin is electronic, if it's generated electronically, then this will apply. Just because it says any electronic record printed on a paper doesn't mean that everything comes into its compass. Then stored, copied, recorded in optical or magnetic media are the words, or semiconductor memory. So as I said, CD, DVD, pen drive, these chips, everything will come in, Blu-ray disc. So all of this becomes an electronic record. But it then says that it shall be admissible in any proceedings. It shall be admissible in any proceedings without further proof or production of the original. Please mind these words. I am asked many a times as to, do I need to produce the original electronic device in the court of law? And what if I have an original device and I am producing that in a court of law? Friends, I have an answer to this, and please understand this. You may be having an original record. In fact, Justice Nariman in one of the judgments says that, if you have an original, don't certify it. Now, I have some technically different arguments, but let's not go into that point. Please understand this. Though you have an original, are you required to produce it? No. The section tells me without production of the original, it shall be admissible. So one thing is clear, the law does not compel you to have the original. Question that the clients pose me, do I need to preserve my original? Yes, as far as possible. Is that been allowed? Oh, thank you. I'll just do that and let me know if is it visible, Vikashji, what I'm showing on the screen? Okay, I think it is. Okay, no problem. Without further proof or production of the original. Can you just see the highlight which is happening? Vikashji, if you can just tell me so I don't miss out on anything. Is it there? Okay. Yeah. Without further proof or production of the original, please mind these words. So you are not required to go for any other proof. You don't need to produce the original. So please do away with the concept of the original stuff. There is no requirement of the original thing. That's one. Okay. What are the risks associated with producing the original? The first risk associated is that you may lose your data. What if there is a strong magnetic force brought near your device? It will completely obliterate the data on the device, leaving you without any counter copy. Please therefore never take a risk of the original. One. Second, imagine your matter traveling and is inevitably going to travel to the appeals, in the revision, in a writ. Are you going to carry around the original device? Is your R&P going to have the original? No. Therefore, please don't produce the original. You may say that, no, I will just tender it and I'll take it back. No, that's not how the evidence works. You have to have, and we will go to the certification. It has to have a hash value. So if your original is within the custody of the court, then you have no means to independently corroborate the hash value in the event if it is disputed by the other side. So don't take a risk of ever producing the original in the court of law. Just because you do not want to have a certificate, this is too a risky shortcut is what I will say. So please mind these words, without production of the original. Now please mind these words, any contents of the original. So what is the or any fact stated therein of which direct evidence would be admissible. Please mind these words. Whenever you are producing a certificate, it is the proof of contents of the original. So you don't need to again get the original. It is a proof of contents. Now, please mind here, for my junior colleagues at the bar, proof of contents is different from the proof of veracity of contents. So if someone says that, if someone I receive an email saying that there was a match at Wankhede Stadium yesterday, I put that in a court of law. And if I produce 63, it will only prove that indeed Mr. Narvankar received an email that there was a match at Wankhede. Will that actually prove that there was a match at Wankhede? No. So the veracity of a content is different from the proof of content. So mind this, 63 will only prove the contents of the original. The veracity will have to be independently proved by the proponent. Or any fact stated therein of which direct evidence would be admissible. Direct is what you know, a rule against hearsay evidence. If it's something which can be seen by eye, it must be an evidence of an eyewitness. Something which can be heard, it must be an evidence of the person who heard it. So this is a case of a direct, this is what is the definition of a direct evidence. So please understand this. We are now approaching towards section 63.4. By the way, you can skip, these conditions. Now the computer output was produced by a computer, when it was used regularly, the information was fed regularly into the computer. It was operating properly. It is derived in the ordinary course of business. Please, you can, bypass now all this. I'll tell you why. It's because of this section, subsection 4. Now, under the new subsection 4, you can straight away give a scheduled certificate, and you don't need to really go into threadbare into section 62 subsection 4. I hope the screen sharing has stopped. I hope so, Vikas. Is it stopped? Okay. So coming back to 63.4, please understand this, that now a certificate has come. This certificate will take care of all the ingredients of section 63 subsection 2. So these 4 conditions that we just cursorily glanced through is not required to be now independently said. So the certificate will take care of that. And for a certificate, 63.4 is something very important. Please understand, this is now we are coming to the heart of today's lecture, of how to go about a certificate and how to make it error-free. And I'll also tell you how to go about experts, which experts to be approached, how the experts should be dealt with. Before that, let me also just, for a minute, take you back to section 63.4 and show you where the law has changed. Okay. Please see, in any proceedings where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following shall be submitted. तो आपको ये certificate देना है. Please note the words along with the electronic record. Where many a times a question is asked to me कि कब देना है, पहले मतलब along with electronic evidence देना है, पहले अगर आपने record दे दिया, बाद में अगर हम देते हैं इसको तो चलेगा क्या? Please mind now. Now law specifically says it must be along with the electronic record. Please mind these words, at each instance where it is being submitted for admission. Very, very important words. These were not earlier there in 65 capital B. So the certificate must accompany your electronic record at each of the instance where it is being submitted for admission. Now, what is admission? Admission means putting something into the evidence. It's an evidentiary stage where you admit a document into the evidence. Okay. So admission again can be bifurcated into formal filing and exhibiting of a document. Now, let's not go into those threadbare distinctions. Safe is to assume that अगर आप कोई document आज की तारीख में कोर्ट में submit कर रहे हैं, तो please ensure that you do that along with the certificate because of a very clear mandate at each instance where it is being submitted for admission. Fine. Now, what it has to contain, and I will go to the certificate straight away. Identifying the electronic record, आपको electronic record identify करना है. You have to give particulars of the devices involved. We'll discuss about this, dealing with the matters. Just for a minute, let's just go to one of the slideshow I have just prepared for you. And just give me a sec. Please look at the screen. Can you see the slideshow, Vikashji, on the screen?
Yeah.
Yeah. Okay. So, uh, so this is a certificate format in the Indian evidence for the Bharatiya Sakshya Adhiniyam. Now I am going to first part B and we will come back to part A. Now this certificate comes under section 63 subsection 4C. This part, it is to be filled in two parts. Part A is to be filled in by the party and part B is to be filled in by the expert. There is a reason why I am starting with part B, because most of that, 90% of that is overlapping. Okay. So first see, आपको नाम डालना है, the one who has come to you for certification, name, son, daughter, spouse, residing, employed at so and so, solemnly affirmed and sincerely state as follows. I have produced electronic record, output of a digital record taken from the following device, digital record. Please understand here, you have to tick mark only one of them. Either it is a cloud, for example, अगर Google Drive है, iCloud है, it's a cloud, it's a mobile, computer, server, CD, flash drive, or DVR. You have to mark it. Now, always mark this with the consultation of an expert. Sometimes it so happens that an electronic record may be overlapping. For example, it may be a computer data also, and it may be on a server also. So just discuss with your expert while you are taking this, because this is what you will also find in part A of the certification. It's almost the same. Then other means, if there is something which is not there in any of these categories, you have a liberty to mention that in the other form. Make and model, very easy. If it's a mobile, you just make mention of a make and model. Mention the color of the device. It's very simple. Serial number, IMEI, UIN, UID, MAC, and Cloud ID. Now, this is something where the experts will help you. IMEI is something, and unique identification number associated with each mobile, which is also what UIN is. Now, MAC, multimedia access control, Cloud ID, this is something I would strongly advise you to please get it from the expert to know the exact identification number of the device you are producing in the court of law. Please do not go by your crude sense of knowledge or your bare reading of something on a device. Please take an expert's help while you are filling in this. Any other relevant information about the digital record. Please understand this. If there is something that your expert wants to say over and above the certificate, here is a place where the expert should say this. For example, suppose there is a CCTV footage you want to produce in the court of law, and the CCTV footage is for 2 hours, but the relevant portion is only of 2 minutes. Now your expert calculates the hash value of that 2-hour CCTV footage. However, somehow only the relevant footage is produced in the court of law for the sake of brevity, that only 2 minutes is produced in the court of law. Now, again, our expert will calculate the hash value of the same CCTV footage, which is going to be different from the hash value of the entire CCTV footage. So for the same piece of evidence, we have 2 hash values. Now there is going to be a difference. Now please understand, it is here you need to mention all this. The expert has to mention all this, that there is a trimmed version of this footage. There is for example, it's an image, it's a blurred image. If he does something to increase the sharpness, the contrast, the clarity, it is here the expert has to say out. Therefore, this is something very important. Then I state the hash value of the electronic record is obtained through following algorithms. This is important and also easy. It's kind of SHA1 is a secure hash algorithm. SHA-256, MD5. These are the ways and means of calculating hash value of any any electronic evidence. And there are, and we will talk about this in a little later part of the uh, talk today as to how do they differ and what impact it has got in a trial. Okay, so you have to have an hash report to be enclosed with the certificate, and this hash is something we will just see how does it look like. Take a case where I have to generate hash value for the word India. INDI, it's all in caps. Now, if अगर hash value आप निकालोगे, it will look like this: SHA1, SHA-256 and MD5. अगर आपने आपके घर में भी अगर हैश वैल्यू निकाला तो आपका यही आने वाला है if it is of word capital India. Okay. Now just change the one word, one alphabet in this. Let's make it small I instead of capital I in the word India. And you will see it changes. SHA1 is changed. SHA2 changes. MD5 changes. If you compare the two, you will see just with one word, the entirety of that is changed. Just look at this. SHA1, every kind of hash value will change. So this is what the hash value is about. The moment you have any change in the electronic record, it will completely change. Now, please mind this, and this is something very important. Would the hash value be something easy in every case? No. It looks very easy, but for an expert now, let me tell you, look at part A of the certificate. It has got all the same columns and all the same rows. There is no difference. Why it is important? Suppose if the example I gave at the beginning, a client of yours walks in with the 400 images. Now she asks you to make to produce that in the court of law. As a lawyer, you will be wondering as to why do I calculate hash value of each of the evidence? Why don't I just put that in a folder and calculate the common hash value of the folder? Please don't do that. I'll tell you why. Because hash value of a folder will not be hash value of an electronic record. Because folder is like my book rack on which there are multiple books. Now, suppose if the rack remains the same and I take off a book, technically, the entire hash value of the folder will change. The contents of my book rack will change. Therefore, there won't be any means to understand which file has disappeared, if at all there is a change in the contents of the folder. Also, if there is any tinkering with any of the file which leads to change in the hash value, you have no means to know which file in the folder has undergone a change. That's second. Thirdly, folder is not an electronic record. Folder is a brief in which you are carrying an electronic record. It's like saying कि अगर मैं मेरे बैग का हैश वैल्यू निकालूं क्या उस जिसके अंदर इलेक्ट्रॉनिक रिकॉर्ड मैंने रखा है. No, it's a bag. It's something to carry. You can't have a hash value of something that is just carrying the electronic record. So please avoid the temptation of calculating the hash value of the folder. I have seen this mistake happening on so many occasions. So always remember electronic record. Therefore, अगर आप देखोगे तो in that options, you did not see folder. It can be either mobile, it can be computer, it can be CD, it can be DVD, it can be pen drive. It can't be a folder. Please understand this. It's not an electronic record. So, one. Second, hash value. Don't calculate the hash value of part B yourself. This is a temptation you must avoid. Many times, I have seen this unfortunately happening of late, that generally to avoid, I won't say expenses always, but sometimes, to make it, to have a shortcut, you generally avoid going to the expert. And, you may just call up your friend who has done some IT thing or who knows something about IT, or someone who has done MSc IT kind of thing and ask him to give a certificate. Please don't do that. I'll tell you two reasons. One, please remember that your expert is going to be confronted for your electronic record. Each thing that you say in your certificate is going to be cross-examined thoroughly, and your witness must sustain through that cross-examination. For example, if you are an expert who comes in my case, I might ask you to tell me the difference between SHA1 and SHA2, how it has evolved through the time. Why did you not calculate this kind of hash value, which is apart from these three categories? You should be able to know that. Which according to you is a superior form of hash algorithm? Your expert should be able to tell that. Which app did you use? What is the licensing? What's an authenticity? What's an integrity? Was it online? Was it offline? What was the certification of that? Have you used it before? Did you try it for an error? Is it your homegrown software? It's an online free available software. Can you assure that nothing in the evidence undergone a change while you were calculating the hash value? How do you authenticate the electronic record, rehearse the hash value? So these are, I can just go on. So your witness, who is an expert, should be able to answer all this. Now, please mind here, your part A, the law has done that, and we have now no option but to accept it after the judgment of Pune Bar Association. But please understand the anomaly. Something that the law understood is a domain of an expert in part B. A law should not have asked a layman to do that in part A. If you look at part A also has a hash value. Now the law knows it's an expert's domain. Then why are you asking the layman to do that in part A? Unfortunately, that is the fact. So please understand that take an assistance of the expert even for part A. Understand from him what are the nuances. You do it. No worries, you do it. It's supposed to be done by you. No difficulty. There shouldn't be a variance between part A hash value and part B hash value. If there is a variance, there should be a reason for that. For example, possible. Part A, as I give an example, maybe a CCTV of 2 hours, fine. And the expert just has 2 minutes. He will be like, why are you asking me to get the whole thing done? I'll just trim the footage and give you a hash value. There is a difference in the hash values. Please understand. You have to explain these differences in your certificate, and the expert can do that. One. Second, please understand this. One more thing. You might be tempted to also cut, copy, paste from the hash value of an expert. Never do that. Don't do that. For your own safety and your own the integrity of electronic record, independently calculate the hash value before you give the evidence to the expert, or you go to his chamber, you go to his office, and then calculate the hash value with his assistance. आप वहां पे रख दीजिए उसको, and आप expert को बोलिए कि भाई सब अभी आप निकालिए इसको, and then you compare the two. So don't do the cut, copy, paste, because you're also going to face the cross examination exactly the way the expert is going to face it, and you can obviously sit with him and prepare for a cross. You can obviously say, see, मैंने hash value निकाला है. Please don't ask me what is the difference, what is this. Part B का मेरा expert है, वो आके आपको बोल देगा. You can define your cross examination sphere by demarcating the lines, but your expert should be able to answer all of that. Coming to the next point, please understand this. When you are talking of an expert, don't catch hold of a friend or someone that you are aware of. That expert should be available when you are calling him in the court of law, because an evidence which is not confronted or which is not cross-examined, that the worth of that evidence, there are so many judgments out there. So if a witness is saying something on an affidavit, and if you do not produce him despite the summons of the court can draw an adverse inference under, I think it was 114G in the IAE, Indian Evidence Act. Now I think it's 119G. Adverse inference can be drawn against an expert, and your entire testimony may be vitiated because of that. So an expert must not be only a chamber expert. He should be able to stand with you throughout the trial whenever he is called upon to corroborate what he has said on an affidavit. Then, should you give original to the expert? Do not give an original to the expert. If the expert wants it for a corroboration, you can sit with him. You can, give a copy, and you can bring back the original. If you give the original to the expert, there is a possibility, expert might inadvertently misplace it, and you will be losing the very good source of evidence that you have with you. Okay, but as I said, original isn't that required, but it's always good to have one. So don't generally make a forensic copy, a mirror image. Now, what is a mirror image? Expert will make a copy of that mirror image if you want, or you can make a copy of that. Mirror image means a bit by bit copy. Whenever, for example, if this is a mobile, इसका मैंने plain copy निकाला, and इसका मैंने forensic copy निकाला, there is going to be a huge difference. 1 GB mobile का मेरा forensic copy जाएगा 1.5 GB में, और 1 GB का mobile का मैंने simple copy निकाला तो जाएगा 1 GB में. Why? The bit by bit copy occupies more space because it comes also with the deleted spaces. Okay, you think it is deleted, it is not deleted, it is lying at some corner. The fragments are there. Everything comes in a forensic copy. So forensic copy अगर आप उसकी निकाल सकते हो, well and good. Please give it to the expert. Are you entitled to a forensic copy from the other side? Yes. If you look at the judgment of Dharamveer versus CBI Justice Murali's judgment, he says, and even in a reinvestigation trial, criminal investigation judgment of the Supreme Court, you are entitled to the forensic copy, particularly the accused, under section old 207, along with the charge sheet, you must have a forensic copy of the electronic record. So, so the point is this, that please understand, do not ever trust the original with anyone. Please keep it always with you. Then please, one more thing before I forget. Whenever an expert is giving a hash value, try to have that hash value certification in triplicate or in a duplicate. So you have one for yourself and one you file in the court of law. And let all the 3 copies be signed by the expert. Do not just take one certificate and Xerox it thrice. You should have at least 3 to 4 original sets of these certifications. Okay. Then many times I have seen this, hash values are left blank. If you leave the hash value blank, it has no importance whatsoever. So always fill in the hash value. The blank certificate has no value in the eyes of law. Then at each instance means that whenever you are filing a evidence, you have to have that. So do not defer. Now, again, I don't want you to go back to the basics because I have spoken about it enough number of times, but just to give you a quick recap, see, Navjot Sandhu judgment came, which says no special treatment to electronic evidence. It's just a secondary evidence. Then you had what? Anwar versus Bashir, which said no, it's a special genre. Please give it a special treatment. Then again, judgment of Arjun Pandit Rao came, which reinforced this position. That's a special evidence. Please treat it that way. You have no bypasses. Then comes Sonu judgment of 2017. Sonu says that if you have to raise an objection, you must raise it to the lack of evidence at the very stage when the document is produced. If you do not waive it, then it is deemed to be waived. Please understand this. So if you're standing in the shoes of a defendant and a plaintiff produces an electronic record, if you have to raise an objection, you have to raise it immediately when he produces that. Now 63.4 very specifically says, whenever the document is supposed to be admitted, you must have that evidence. So now what Sonu said is now legislatively corroborated. So you must raise an objection then and there. Hiremet judgment is also there. I'll share all the judgments at the end with Vikashji and he'll put that in a link. Nasir's judgment is there 2023, which says that in the interest of justice, mid-trial also you can do it. But please understand, legislatively the position is changed. So please don't go back to Hiremet, Sonu or Nasir. Let's go to 63.4. You must have it whenever you produce the electronic record. And as I said, Pune Bar Association judgment. That not overrules, but it says that Madras is incorrect law. What was that? This is coming to the crux of the session today. Earlier, the talk of the town was that Madras High Court said that if you want to have an expert, it must be 79 capital A expert of the Information Technology Act. Who are these experts? These experts are the ones who are certified by the government. जैसे आपको forensic lab रहती है, the metro towns, or in Hyderabad in Pune there is one. So these are the government approved labs. Now the law was this, or rather the understanding was this, that you have to have a certification by these labs. Supreme Court has said no. Please look at 39 of BSA. 39.1 is very clear that any person who is expert or who knows about computer or these matters, he is an expert. So even a private expert will do. Please do away with the conception that you have to go to a government approved lab. No. It was actually a part of SOP of Home Ministry earlier, which was rolled out immediately after BSA. But fortunately for us, Supreme Court also now says this, that 39.1 expert, 63.4 expert, Part B, Schedule certificate expert is not a government approved expert. A private expert is what is expected by the legislature. So please understand this. So you have now a liberty to go to any private expert and get your certification done. Now, who is the expert? Any person. Hash value when? Let's just quickly recap. When hash value? Every time when you are going for a certification, don't skip that. Now, is it a precondition? Yes. Is it curable? No, any longer. It's not really a curable. It will vitiate the evidence. Each instance, with every tender, it must go. If there is an original, no certificate? Yes. But again, as I said, it's a very risky proposition. What if you lose the original and if there is a tinkering with the original? tinkering with the original, it goes. Also, I am technically of the view that even if it's an original, it must have the certificate, even if it's an original. Okay, because how else will you authenticate the data? Because you may give original in the court, the defendant has to have a copy. You can't have two original. One goes in the court. What happens to the other side? They have to have the authentication. Therefore, you cannot say possibly that if I'm giving original, there is no need of a certification. Sorry, how the other side is going to believe your virgin? How are you going to authenticate your data? Okay. Now, all trial, which law? Very clear. Before 1st July 2024, the the Indian Evidence Act will apply. Then, please remember, who signs it in part A is very important. Suppose if it's a Google or it's a WhatsApp, or let's assume take a case of my own office CCTV camera. If it has captured something, and I'm not going to come to the court if I say this. Sorry.
It's fine. It's fine. Nothing.
Sorry. Am I audible, Vikash?
Yeah, yeah, perfect, perfect.
Oh, sorry. There was some at my end. Yeah. So please understand this. That see, suppose if I say I'm not coming to the court of law, and it's then who is going to certify that? Now, in this case, you have an option to summon me under section 165 of the old Indian Evidence Act. So, if you look at Arjun Pandit Rao Khotkar, you will see many such sections where the Honorable Supreme Court has given you a leeway to summon these people to the court of law. If you resort to these sections, you may successfully, or at least the law will presume that you tried your best to get those people to the court of law. Despite that, if I refuse to come to the court, apart from my consequences in law, you will have a liberty to produce that in a court of law, though it's my CCTV. And therefore, if you look at part A of the certificate, it just not says owned, it also says operated. So because I am the one who is operating the data, I am producing that in the court of law, I am the one who is operating it. I'm the one who is managing the data. Therefore, I also become entitled to sign part A certificate. So please understand that in the event the owner refuses to attend the court of law, then you have an option of certifying the data yourself. You don't need to then wait for the owner to come. Vikash, am I audible properly?
Perfect, perfect.
Okay, sorry. Then one more thing. Suppose if it so happens that you are also an expert. This happened in one of my recent cases where it was an IT engineer whose evidence was to be produced. He said, sir, I am also an expert. Can I also give the certificate of part B? Please never do that. Part B certificate is supposed to corroborate part A. And corroboration can happen only when it is by independent person. It's like I writing an exam and I giving marks to myself. That is not what is supposed to be done. So let's have part B always by a separate individual, an expert. Never go in for a temptation of having it done yourself, though you are an expert. Then, is it required at an interim stage? Yes. Don't run a risk, even if it's a bail. Please do it. If it's an interim order under Order 39 injunction, don't risk it. Have a certificate always handy. Generally, the rigors of strict evidence do not apply at these stages because, it's an exigency of the situation that requires the interim relief. The court may not do that, but, higher up, you may face the difficulty. Arbitration, not required. Section 19 is very clear. But again, I will say, don't take a risk. There's judgment, I think, of AEZ Infratech of Delhi High Court saying that, and this is something risky. The arbitral tribunal there said, I'm not going to look into the electronic record. It requires a foundational integrity. Forget about 63.4. I wanted a certificate, to believe it myself. And I'm not going to read that into evidence. And Delhi High Court refused to interfere into that award, saying that it's, the tribunal is a master of its own procedure. So you ran a risk of having it produced without the certificate. Never do that. Even in arbitration, may not be strictly in the format, but try to follow the format as much as you can. Unexamined expert, last point. Don't have an expert who will refuse or who may not be able to come to the court of law. Now, who are these experts? Where do I get them? This is something I am often asked, by so many of the law enforcement agencies and the private clientele. See, I have worked extensively in this for last many years, and I realized, I must concede that it is easier said than done. In my lectures, I used to say that find an expert, get an expert, and then my clients and my briefing lawyers told me how difficult it is to get the experts on board, and it's very difficult to find them and to get them and to have them till the end of the trial. Now, I have found few good firms. Obviously, at the end I'll put the names into the box as well, and there are many. But the problem I have found with many of them is that sometimes they do not cooperate for the trial. They give a certification which is something without uh, taking you into confidence. For example, you go to them with a pen drive and you leave the pen drive there. They will give you a certification. That is not what is important. What is important is that they should sit with you, understand what is exactly you are trying to prove in the court of law. They should be able to tell you part A certification, how you should be doing it. They should be able to cohesively have that certificate because it is integral whole, part A and part B. It was not that I give part B, aapka hai, aap leke jao. It can't be that. And therefore, with my own, and there are obviously some experts have joined us as well, where we have this venture called Certi Legal, which is just to help, these certificates to be given by the experts. And we have tried to, this was really out of this urge to help lawyers and the litigants alike, that where you are not finding an expert, so you have to have a technical people and the law people on board, and therefore we have tried to assimilate them and have the symbiosis of the two. And this is, I'll give the details in the chat box of this firm called Certi Legal. It is based in Pune, but they have branches everywhere, and I think they should be able to help you in all these kind of trials. But mind you, that you please be on board with these experts whenever they are doing their job. Please don't try to because to save a penny, don't lose a pound. That's what we call it. So please try to have this certification process done very thoroughly, and you be part of that. Don't just delegate and forget. And you will understand what I'm trying to tell you. When the matter will travel in the appeal, matter will travel in the writ, and your evidence will be questioned just on this ground. Then, coming to the last part of the talk is, what if an evidence is obtained by you illegally and you are trying to prove it, or that evidentiary foundation is something you want to prove? Let me just tell you this. Let me explain this to you. Suppose it's my wife's mobile. I am the husband in a family litigation, and I have, kind of have a spyware on her mobile, and I have produced that in the evidence. It's illegally obtained evidence. And as I have discussed in my earlier sessions, the doctrine of fruits of poisonous tree doesn't apply in India. You can very well produce the illegitimately obtained electronic record also in the court of law. Point is this: when you go to an expert, you must tell him that you are not the one who is the owner of the data. You must be candid enough with him to tell him that this is what is the source of my acquisition. Why? I will tell you. Suppose if the electronic record it's a screenshot of a mobile. Now, hash value of that screenshot will be different from the data of which you took a screenshot. For example, there is an image and I take a screenshot of an image. The hash value of that screenshot will be different from the hash value of an image. You go to an expert with that image and you tell him, please get me a hash value of this snapshot. You produce that in a court of law, and the other side will calculate the hash value of the image of which you took a screenshot. That hash value is going to be different from your screenshot's hash value. And if your expert is cross-examined, and if he's not aware of this, then he will fumble in a cross, because image look-wise they are same. Screenshot will exactly look like an image, but the metadata of an image and metadata of a screenshot will be different. Metadata means data about data, the basic data. Now, this is going to be different. And therefore, if you are candid enough with your witness, with your expert, that this is a screenshot of, let's say, my colleague's mobile. This is not the image itself. He will have that foundation done in the certificate. Okay, he will be able to withstand the intensive cross-examination. So be very candid. What's the source of your acquisition? Is it admissible? It is admissible. You may run a risk of, breach of privacy, and under section 43, there have been cases where, illegitimately your data is accessed and you have been able to, someone has to face the wrath of adjudicating officers for breach of privacy. But that's apart. Evidentiary speaking, it is admissible, but you must caution the expert on this. Okay. Then, as I said, Order 16 gives you enough leeway to call the owner of the data. Section 91 of old CRPC gave you a leeway to call the owner of the data to the court of law. 165 of the old Indian Evidence Act again gave you enough leeway to call the owner of the data. So you have all these means by which you can call the owner of the data to the court of law. And with this, you can certainly prove the electronic record in the court of law. Yes, and there is one more thing, just to conclude. You may also have to prove, you may be tempted, to prove the authenticity of a data. Please listen to this carefully. Me giving hash value of, for example, my lecture is today recorded by Vikashji. Suppose it is to be proved in the court of law as by way of evidence. He will calculate hash value of my lecture and he will produce that in a court of the audio file or the audio visual file. Would that really mean that it is Yuvraj Narvankar who has spoken this? Not necessarily. You have to do what is called as the spectrography analysis to identify my voice. That voice in this is the voice of Mr. Narvankar. Otherwise, with the age of AI and all that, you can just superimpose any voice on it. But please avoid the temptation of going into this nitty-gritty. Why I am telling you, please go back to the language of section 63. It says without further proof or production of the original. What do you mean by further proof? This is further proof. Spectrography analysis, noise analysis in an image, because if you alter an image, you can see that in the noise. There is always a noise in the image which is edited. Don't go for all this additional evidentiary burden unless you are called upon by the other side. Once, the beauty of 63 is this, once you have a 63 certificate, the burden of proof is, the onus of proof is shifted on the other side to disprove that electronic record. Let them come out with the evidence that this is what it is. With the forensic image that you have given to them, this is what it is. Or at least let them allege that this is the tampered, this is AI, this is a deep fake. Let the court call upon you under 165 to do that. Then you embark on that journey of additional authentication. Without that being asked to you, if you take upon yourself this great burden of also giving the foundational integrity to the electronic record, you may end up being too overburdened in the course of the trial. So that's it for today. Thank you so much for having me here, Vikashji. I'll open it for question and answer session.
We will take few basic questions because sometimes in 1 hour journey, one tends to forget. So these will be very focused questions, which are only primarily this. Yes. It says, why was section 63 of the BSA introduced and how does it differ from section 65B of the Indian Evidence Act?
Now, see, frankly, there was major difference was with the stage of electronic record when you have to, the stage of a certification. Earlier, it was not clear as to when you have to have a certification. Now it's very clear along with each and every stage. It's called, also there's a concept of a contemporaneous certification. As and when you are calculating the hash value, as and when you are deriving an electronic data, you must calculate the hash value of that data for its integrity. Hash value concept, which was challenged by Pune Bar Association. It wasn't there earlier. Hash value is really what gives it the authenticity foundation. Because suppose if I'm calculating hash value of an electronic record today, and if I calculate that after 10 years, and if they match, it means my electronic data has not been tinkered with. It's same. Now, this is what has been brought. And earlier, again, we did not have a format. I used to be approached with so many queries, give me an ideal format of certificate of 65 capital B. Now, with the addition of a schedule, it is made so easy. 63.2, as I said, you can just forget, you can straight away, you can skip all that and go to 63.4 and the schedule. It's all now a format, standard format. I think these are the changes the legislature wanted to bring to get the uniformity in the trial. This was the reason.
And now it says, is section 63 certificate mandatory in every case which involves electronic evidence, electronic records?
Without fail, this is something very important, and that's the reason, Pune Bar Association judgment. There's the reason of we are meeting today. Now it is compulsory. Now no way you can go, you can bypass this. This is something now mandatory in all the respects. You have to have it.
अब नेक्स्ट क्वेश्चन है कि भाई ऐसी कौन सी कॉमन ड्राफ्टिंग के टाइम गलतियां होती हैं which results in rejection of your application by the courts?
Application, I take certificate.
Yeah.
Okay. Yes, good question. Not ticking the right boxes, one. Secondly, giving incomplete hash values, second. Thirdly, not identifying the electronic record in the correct manner as the legislature has contemplated. And fourth, not identifying the unique device identification number. These are the 4 ways and means your certificate may be vulnerable to challenge. Please understand this. Whenever you are giving a certificate, the other side is going to take that certificate to its own expert, and they are going to literally go threadbare and tear apart your certificate with the cross-examination. Tear apart in symbolic sense, verbally, and they are going to cross-examine you. Therefore, as I said, your expert is going to be of tremendous importance to make these certificates immune.
क्या एक वकील certificate issue कर सकता है section 63?
No.
On behalf of the clients.
Never. See, I'll tell you, 63 schedule certificate, part A is to be by the client and part B is to be by the expert. Part A is not by the agent of the client, not by the representative, attorney, leader of the client. However, assume for a minute that you are dealing with, let's say, a illiterate, very old, aged lady from some rural area or some guy from there. Then in that exceptional situation, you may assist that person to derive a hash value, and you can have to write that, what are the exceptional situations that led you to give the certificate, and you can't then say owned, you have to say operated. But between owned and operated, owned is always preferred because that person can vouch for the data. It's his or her own device. So except barring this situation, a lawyer or a pleader is not supposed to give the certificate. That's not at least the legislature intended.
Yeah. How should WhatsApp chats, voice notes, photographs, and videos be certified?
Sorry?
How should one get it, these certificates in respect of WhatsApp chats, voice notes, photographs, and videos?
The experts will tell you the WhatsApp chat can be exported in variety of formats that can be hash valued. Then videos can be done. The trimming has to be done. Images can be independently hash valued. YouTube videos can be recorded and they can be hash valued. Website pages with the live recording or something called as a duck capture. In my book, I have given ways and means to capture this. And if you, let me tell you, your expert should be so approachable that if you go to him saying that, I want this evidence, then he should be able, for example, it's a defamation. On a website, there is a defamatory content. Don't try it at home. Go to the expert. Understand the situation. Try to make him understand. Let him take out the website. Let him capture the website for you. And then let him, so involve him from day one. Don't go to him with some self-acquired evidences if you want to be doubly sure of the source of acquisition.
This is what is the correct certification process for Facebook, Instagram, X, or LinkedIn?
No, it's the same. See, LinkedIn, Instagram, Facebook, you would be talking not of a website or an app. You are talking of a post. Now, this post can be captured in a variety of ways. It can be way of a screen capture. It can be way of an export. It can be by way of a saving. There are multiple ways. Again, I have spoken about them in my book. Now, each of them has a different modality. Better, again, you approach an expert. The crude way, if I may put it that way, is to go for a screen capture. You can do that. But understand, the screen capture is an image. It's not a post. The metadata of a post will be different from a screen capture. So therefore, WhatsApp, you can, take a screenshot of a chat and you can produce that. or you can export that chat and calculate a hash value of that. The second will be always better scenario in terms of the authenticity foundation. So each device will come with its own ways of acquisition, ways and means. Nothing is bad, but it's between good and better. It's not worse, it's between good, better, and best, the modes of acquisition. Please share expert who is dealing with this. No, I said Rita. Rita, the same. As I said, CertiLegal is one I have worked for a longest time now, and I have found them good. And I'll obviously give the details at the end with the Vikashji. But one thing is for sure, don't go for the government approved labs. They do not have generally, they will not entertain you, because that is also a question. They will not entertain you for private queries. It is only when the court is referring these matters to them, they will entertain. Private queries, they don't entertain.
It says
devices produced in court. Yeah, because
who would issue the certificate for CCTV footage?
Now, again, twofold. One, the person who is in charge of the device, and second will be the expert who is going to certify that. Ethan has asked if I have 5 screenshots, 10 videos, 2 audios, is it necessary to create different? Yes, has to be that way. As I said, don't go into the folder business. That's not what is expected to be done by the law.
It says, at what stage should the certificate be filed in the proceedings?
As I said, the law now says along with the electronic record, whenever you are whenever you are tendering the electronic record, you are getting it admitted. You have to, for example, let's take a case. मैं cross examine कर रहा हूँ witness को और मेरे पास एक उसका email है. He says, I ask him कि sir, had you sent this email to my client ever? He says, no, मैंने नहीं कभी भेजा. I have to confront him under old section 145 of the Indian Evidence Act, confronting a witness with his previous statement in writing. The Tahsildar Singh, the whole line of judgments. Now I am confronting with the email. Now the Bombay High Court says, I'll give all those judgments, that even while confronting him, you should have a 63 or 65B old certificate handy. So whenever you are moving a document into admission, along with charge sheet, always preferable. So whenever you are doing it, it should be along with the electronic record.
Yeah, and this is how should AI generated images, videos, or audio recordings be authenticated?
You cannot, you should not authenticate something done by the AI. It's outright creation or concoction. So there is no way. And let me tell you, there are also, visually you can identify something done with the AI. I think now everyone has got that much of an eyesight. You can immediately, identify one. Secondly, the AI will have a limitation. It will not have a backup copy. It will not have a source. The only source of AI may be ChatGPT or a Claude or something of that, the similar nature of an app. It will not have a source like I capturing an image of a tiger in a forest. I will have a camera. I will have a memory card. I will have something, where I have stored it. But a tiger generated image of a ChatGPT will not have any backup. So that is another way of confronting the witness, that please show me the backup. And when you go to an expert, he will immediately ask you, what is the source? What are you asking me to identify? Fine, you are asking me to give a hash value of the image. What is the source of an acquisition? And therefore that, please mind now. Now you will understand the importance of a certification, why Supreme Court uphold it. Therefore, now you will remind those columns. What is the nature of an electronic record? It's a CD, DVD, cloud, storage. Now, what will you say for AI? You have no device of procurement. You have no device of the source. And there you will fall short. And therefore, I think AI will have its own limitations in the court of law. Though it looks very fearsome, but AI will fall down, when confronted properly.
It is as good as what we say, that a truth will remain a truth, even if one person says is correct, and a false will be false, even if 100 people say that.
Amit Deshmukh has asked something good. I just want to answer it. If I want to prove printed document, how can I? Sorry.
Just read that question shortly, because you would be reading it fast, because people who are not on the chat on the YouTube will not be able to understand. Just read that question short.
Sure. Mr. Deshmukh asks me कि printed document का hash value कैसे निकालना है? Print of an email, print of any report. No, please understand. You cannot calculate hash value of a print. How will you calculate a hash value of a print? Print is something printed on a paper, which is electronic record printed on a paper. Look at the language. So you will have to calculate a hash value of an email, not of a paper. So the hash value will have to be 1. Second, what if you don't have an email and that is lost or that's formatted? It's just the print that you have. Then sorry, you don't need to calculate the hash value. It's a secondary piece of evidence, pure out and out secondary piece of evidence. A copy made from the original by a mechanical process. A classic case of a secondary evidence. You have to lay a foundation why the original was lost and destroyed. Now, application is not necessary, as the Bombay High Court had said, for secondary evidence. You can just lay the foundation and you can produce it. But don't confuse that with the electronic record. It's not an electronic record. It's a print on a paper.
Yeah.
How to certify image from the Google Earth? Same.
So now we'll just ask you to describe this entire session in around 10 minutes in Hindi.
Sure. Sharat Dhore asked, please give contact number of an expert dealing with this. Yeah, CertiLegal, I'll at the end will surely share their number, and if they can obviously help you along. Hindi mein agar isko abhi, I'll just capture this in Hindi, try to understand.
Topic se start.
Yeah. Hindi, because I might find it little difficult.
It's fine.
You will excuse me, pardon me for my language lapses. Basically, electronic evidence.
What you can do is you can explain it in Hindi English mix.
Yeah. पुणे बार एसोसिएशन के जजमेंट के बाद में दिस इज बिकम वेरी इंपॉर्टेंट कि आपको हर केस में इलेक्ट्रॉनिक रिकॉर्ड ऑथेंटिकेट करना ही है. इलेक्ट्रॉनिक रिकॉर्ड ऑथेंटिक करने के खाली दो इंपॉर्टेंट पार्ट्स है, सर्टिफिकेट पार्ट ए का और पार्ट बी का, जो आपको 63 के अंडर मिलता है. 63 के अंडर वाला जो सर्टिफिकेट है वो पार्ट ए वो क्लाइंट ने भरना है उसको, और पार्ट बी को एक्सपर्ट ने भरना है. अगर छोटा केस है, इसमें ज्यादा इंपॉर्टेंस नहीं है, तो हम इसको टाल सकते हैं क्या? द आंसर वुड बी स्ट्रेट नो. आपको करना ही है अगर आपको इलेक्ट्रॉनिक रिकॉर्ड को एग्जिबिट करना है तो. इफ यू वांट टू गेट इट मार्क्ड इनटू एविडेंस, आपको करना ही है. अभी हमने फिर एक्सपर्ट के बारे में बात किया. एक्सपर्ट कौन है? तो आपको गवर्नमेंट लैब में जाने की जरूरत बिल्कुल नहीं है. यू कैन जस्ट कैच होल्ड ऑफ एनी एक्सपर्ट जो आपको एक्सेसिबल है, जो आपके साथ ड्यूरिंग ट्रायल खड़ा हो सकता है, एंड जो आपके लिए कोर्ट में आ सकता है. सबसे इंपॉर्टेंट, दिस इज समथिंग वेरी इंपॉर्टेंट, प्लीज अंडरस्टैंड दिस. देन हमने बात किया हैश कैसे कैलकुलेट करते हैं. कैलकुलेशन ऑफ अ हैश इज डन बाय n number of means. It can be offline, it can be online. There are multiple apps. लेकिन मैं एडवाइस ये करूंगा कि जनरली ऑनलाइन ऐप पे मत जाइए. आपका अगर डेटा सेंसिटिव है तो आपका डेटा लीक हो सकता है, पर्टिकुलरली इन क्रिमिनल केसेस लाइक पोक्सो. Expert के without expert's opinion, do not give part A certificate. There might be difference between the hash value जो आपको नहीं समझेगा, लेकिन क्रॉस के वक्त आपको उससे बहुत कन्फ्रंट किया जाएगा. तो आप एक्सपर्ट के साथ के ही बैठ के ही उसको दीजिए. पार्ट ए भी हो या पार्ट बी हो, पार्ट ए में साइन आपका ही लगेगा, पार्ट बी में एक्सपर्ट का लगेगा. एंड आपको जब भी आप इलेक्ट्रॉनिक रिकॉर्ड दे रहे हैं तो आपको इसको कंपल्सरीली देना है. You cannot not give it. And because you just to know some of that in Marathi, I think now this I think
Marathi start with the topic.
जी फार अवघड नाहीये. पार्ट ए आणि पार्ट बी मध्ये हा भाग 2 आहे हा सर्टिफिकेटचा. पार्ट ए हा आपण द्यायचा आहे, त्या क्लायंटनं द्यायचा आहे, वकिलांनी द्यायचा नाहीये. पार्ट बी जो आहे तो एक्सपर्टनं द्यायचा आहे. आणि हा एक्सपर्टनं देत असताना हा कुठलाही गव्हर्नमेंट एक्सपर्ट असण्याची गरज नाहीये. हा कुठलाही एक्सपर्ट असू शकतो ज्याला कॉम्प्युटरचं ज्ञान आहे. सेक्शन 39(1) अन्वये BSA ज्याला कोणाला कॉम्प्युटरचं किंवा संगणकाचं ज्ञान आहे तो कोणीही देऊ शकतो. आणि त्यामध्ये तो एक्सपर्टच असला पाहिजे किंवा त्याला विशिष्ट डिग्री असली पाहिजे हे महत्वाचं नाही. त्याला अनुभव किती आहे हे जास्त महत्वाचं आहे. त्यामुळे साधारणतः त्याचं थोडंसं भान ठेवून इलेक्ट्रॉनिक रेकॉर्ड द्या. प्रत्येक स्टेजला देत असताना तुम्हाला कंपल्सरीली इलेक्ट्रॉनिक एव्हिडन्स देत असताना तुम्हाला हे सर्टिफिकेट देणं आवश्यक आहे. जर तो ज्याचा तो डेटा आहे तो जर हजर नसेल किंवा जर तो अवेलेबल नसेल तर कोणाला अप्रोच करायचं, तर तुम्ही त्रयस्थ व्यक्तीकडनं तो नाही घेऊ शकत. तुम्हाला त्याला समन्स काढावं लागेल सेक्शन 165 खाली जुन्या एव्हिडन्स ऍक्टच्या, किंवा ऑर्डर 16 CPC खाली, किंवा सेक्शन 91 जुना CRPC नवीन ऍक्ट मधला सेक्शन प्लीज बघून घ्या. त्याच खाली तुम्हाला समन काढावं लागेल. तो तरी देखील आला नाही तर मात्र तुम्ही मी तो डेटा ऑपरेट करतोय तर ऑपरेटरच्या कॅपॅसिटीमध्ये तुम्ही ते सर्टिफिकेट देऊ शकता. आणि सगळ्यात महत्वाचं म्हणजे कुठल्याही प्रकारे ते सर्टिफिकेट हे ट्रायल मध्ये टिकेल अशा स्वरूपाचं द्या, जेणेकरून पुढे क्रॉस मध्ये त्या सर्टिफिकेटला कुठे त्रास होणार नाही. ओके, द नंबर्स दॅट आय वॉज आस्क्ड, वन इज द नंबर ऑफ एन एक्सपर्ट दॅट आय हॅव वर्क विथ 72761 00641, and second is 9271.
Posted on the You can post it on the
706.
YouTube link.
Yes, we will do that. We will do that. We will do
Yeah.
that.
Can you share your book, which you have written, because people would like to love that, read it. Those who joined for the first time.
The
Or I will
name
share
of
it.
my book is Electronic Evidence in the Courtroom by LexisNexis. It's into now, after 10 reprints, now it's in the second edition. It gives, by and large, the entire modalities, how you prove the electronic record, and the cross-examination questions that you might expect. So it has got a specimen cross-examination कि CCTV के बारे में क्या questions पूछे जा सकते हैं, वीडियो के बारे में, ऑडियो के बारे में, CDR के बारे में. So basically, you can surely read my book for any additional inputs. Thank you so much. Thank you.
And those who have missed the previous sessions of Mr. Yuvraj, they can watch it. And we are also about to create the playlist of Mr. Yuvraj Narvankar. Otherwise, also you can Google it on the YouTube, Beyond Law CLC and Yuvraj Narvankar.
Because if you just allow, Abdul Sheikh has asked a good question कि telecom networks like Jio gives Part A certificate, not Part B, CDR के बारे में. So this is right. Part B आपको उनका certificate, you have to go to an expert independently for the Part B, and you have to get that thing done. Now the difficulty is this, that if the CDR is not accessible to an expert, you have to make an application to the court and then call upon the telecom operator to give you the details on basis of which your expert can make Part B certificate. Just to answer Mr. Sheikh's query. Thank you.
Thank you, friends. And thank you, Mr. Yuvraj, for sharing your knowledge. We are all